Hello, this is Guy Grant, your Spring Hill, Florida realtor, and today we're going to update you on the Reebholz case. That's the one where the guy was renting a room and in his house, and he had homestead exemption, and he actually lost part of his homestead exemption, and the case went all the way to the Supreme Court. He had actually prevailed in the original case and at the appeals level, but unfortunately the Supreme Court has ruled in favor of the property appraiser, and it's not a ruling I'm too happy with, quite honestly, but I don't have much to say about it, but I would have sided with the lower courts on this one. I really believe that the guy's kind of getting screwed, and that the Supreme Court just gave property appraisers a lot of power that they didn't have before. So if they find out that you are renting a room in your house, they can actually take away the homestead exemption, and the biggest part of that is the 3% cap on the increased value. And in this case, they found that 15% of his property is not covered, and so they took the 15% of his property and then they used a 10% annual increase instead of a 3% annual increase, and brought his bill up by another $7,000, which is really a shame. I actually pulled up the case. That's Bill First. He is the property appraiser in the county, and then there's this Rod Reebholz guy. He actually passed away, but this says most of it right here. We hold that the owner is not entitled to a homestead exemption on the rented portion because that portion is not the owner's residence. And if you read it that way, it makes a fair amount of sense. There's a couple other things in here. The Constitution governs how homesteaded property works, and it exempts it from forced sale by creditors. Now, can creditors now foreclose on 15% of his house? I don't know. This is a whole new area of law that they've opened up a giant mess on, as far as I can see. And of course the 3% cap being the big one. And they even said those provisions are intertwined. Yeah, I mean they've really made a big mess out of this. This guy, this Michael Beaumont, was the tenant and who rented a room in the house. The guy actually ended up having to evict him, and so now you have somebody who's more than willing to testify against the old homeowner. So that's really kind of a shame. But he did have a rental agreement, and so there was a lot of stuff in writing that they used against him. And again, that 15% and then 85% was homesteaded. And up until this point, you either had homestead or you didn't. And the Supreme Court has that's the Supreme Court of Florida has changed that. That's not the United States Supreme Court. And this is where they use 10% instead of 3%, and all that added up. So. And here's what they said. The underlying complaint in this case and the court decision did not address the 15% calculation or the methodology behind it, but rather the authority of the property appraiser to make the apportionment at all. So basically they said, here you go, property appraisers, go nuts, do whatever you want. Really, it's kind of a sad thing. You can see Rob Reebholz did pass away, and this was his son that was taking up the case. And one of the big things, one of the arguments that I thought made the most sense was the part about what if somebody works out of their house, and they addressed that at the very end of the opinion. He said, we conclude with a word about the scope of our decision. Unlike the district court in its opinion, we do not equate Reebholz with the countless Florida citizens who are residing within their permanent residence while working from home. The phrase working from home speaks to activity occurred within the property already found to be the owner's residence. But before they tried to quote that it's the use of the property that matters. So, and in that earlier article that I did, it said that the lawyer for Hearst wanted to charge anybody, Mary Kay ladies who are selling makeup out of their house. He wants to take their homestead exemption away. So that's something to watch. It might be coming. But it says under the Constitution and the statutory scheme, how an owner uses the property, not its physical structure, dictates the availability of the homestead exemption. Using that argument, I think they can come after people who are working out of their homes, and I would kind of watch for that next. So kind of an interesting update, a little bit technical. If you were following this, you might find it interesting. If not, I apologize. I'll try and make the next one a little more interesting. But if there's anything I can do for you, please get a hold of me. Thanks.